Good morning. Are you Kenneth Bartol?
Yes, ma'am.
And Mr.
Right from the start, this looks like a routine plea hearing, but don't be fooled. Multiple charges, multiple cases. This can stack up fast. Question is, how bad is it about to get?
Parker, will your client waive the formal reading of the indictment in each case?
Your Honor.
I am going to first also, I think we've probably done it, but just to make it clear, I'll take judicial notice of the court's file in each of the cases. Mr. Barthol was evaluated by Dr. Capon for competency to stand trial, and we received an evaluation and report back on November 3rd of 2025.
This is huge. The court just confirmed he's mentally competent, meaning he fully understands what he's doing. That makes his upcoming guilty pleas legally solid and much harder to challenge later.
The finding in that is that Mr. Barthol was competent to stand trial. Is there any other evidence with regard to competency today?
No, Your Honor. No, Your Honor.
All right, then based on that, I will find that Mr. Barthol is competent to stand trial and proceed. So, Mr. Barthol, in cause number 25, DCCR 1207, you're charged with the third-degree felony offense of obstruction or retaliation from July 19th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Mhm.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in cause number 25, DCCR, that's a state jail. We're going on count one only in the state jail case.
So is that?
1752.
Yes, Your Honor.
Give me just a minute. In 25 DCCR 1752, the state has elected to proceed on count one only. It alleges you committed the state jail felony offense of possession of a controlled substance from January 11th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
And then lastly, we have cause number 25 DCCR 0878. And in that case, you're charged with a third-degree felony offense of obstruction or retaliation from May 24th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
In all three cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case.
Objection.
It's admitted. Is there any, again, there's no other evidence about competency.
No.
All right, Mr. Barthol, I'm going to find in all three of your cases that you entered your pleas of guilty freely and voluntarily. Find, again, you're mentally competent. You understand the nature and the consequences of those pleas. In cause number 25, DCCR 1752, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 1207, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody
And just like that, boom, multiple convictions. But here's the key detail: the sentences ran concurrently. That means he won't serve them back to back, but still 5 years is no joke. Do you think taking the plea deal was the right move, or should he have risked trial?
That the law gives you the right to receive. And then finally, in clause number 25, DCCR 0878, also find that you entered your plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to go back real quick because I think I failed to mention, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
Okay. These cases will run concurrently, which means together at the same time. I will sign dismissals as part of this agreement in clause numbers 25 DCCR 1206 and 25 DCCR 1208. I'm handing you in each of your cases the trial court certifications. That shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
One, Judge.
Morning. Good morning, sir. You Robert Trahan? And Mr. Trahan, and clause number 25 DCCR 1094, you're charged with the state jail felony offense of unauthorized use of a vehicle from June 3rd of 2025. The indictment alleges that you were previously convicted of accident involving injury or death, a special degree felony, October 16th of 2017. And after that was final, you were convicted of evading arrest or detention with the use of a vehicle, October 17th of 2022, and also possession of a controlled substance, October 17th of 2022. And so that special degree is considered, have y'all done any research on how that's considered as far as enhancement purposes?
I believe it's considered a third for enhancement purposes.
Third, I got him at 2 to 20. Because
No, just right. If that's considered a third or more,
It's not
then it would be
considered.
2 to 20. I just need to know of the special degree, you think it's considered a third?
I believe so.
Which
Just
would
because
make-
the sentence was 3 years, I believe, before one of the two.
I'm confused.
So in the
If it's
indictment,
third degree,
one of the prior felonies that are listed as enhancement is a special degree felony.
Oh, I see.
And so it's on one date in 2017. The other two are on the same date. And so in order for it to enhance, I need to make sure that it's considered a third or more and not a state jail
Now I understand.
for punishment purposes. And so I want to make sure we are all on the same page. What is the range of punishment for that?
Judge.
Degree. I haven't had one like this in a while, so
They amended that statute to be different now than what it was back then, and that's why it was a special degree in the first place.
gotta know what it
It
was.
made the minimum.
Actually, Judge, you know what? I have my criminal history here. Let's see what it.
Y'all do this. Let me hold it for
Yeah.
a minute and just double check what that range of punishment was in 2017.
Okay.
Because that would be the law that would be followed. And if y'all need, I have old books. So let's do that first and then we'll figure it out. I'll just hold the paperwork.
You know, Judge. This is the judgment. So it is not, the indictment in the cases does not allege serious bodily injury, so it is just the generic accident involving injury, which I think puts you under 550-21, under the last, under the last, the general punishment range. Which is
up to 5 years.
Yes, ma'am. And so that actually hasn't been changed at all. That's how it currently reads as well. And my understanding is that qualifies as a punishable enhancing offense for purposes of habitual offender status.
All right. You agree, Mr. Coleman?
Yes, Your Honor.
Okay. Thank y'all for taking a look at that. Okay, so what that means, let's go back then, Mr. Trahan. In 25 DCCR 1094, you're charged with that state jail felony offense of unauthorized use of a vehicle. And in that case, you've got the prior offenses that we went, that I've already gone over, which are 3, 2 on the same date, but then the other one, they are consecutive. And what that means is if you go to trial in that case and you're found guilty and those prior convictions are true, the range of punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand? Answer out loud, please.
Yes, ma'am.
And then cause number 25 DCCR 1317. You're charged with the state jail felony offense of possession of a controlled substance from December 28th of 2024. The indictment alleges those same prior offenses. So again, what that means is if you're found guilty in this case and those prior convictions are true, the range of punishment would be that of a second-degree felony, which is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then finally, in cause number 25 DCCR 1536, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from August 20th of 2025. And it alleges those same prior felony convictions. And in that case, what that means is that if you go to trial and you're found guilty, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison, up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And in all of those cases, I have here on the computer some documents, some plea bargain rejections that you've signed with Mr. Eckhart that show that the state has made offers if you wanted to enter pleas of guilty. And those offers are for, in all of the cases, in the first 2 to go on all of the counts, in the last one, the habitual, to go on count 1 only, for 7-year terms in all 3 of those cases that would run concurrently, which means together at the same time. You have every right to reject that and have all of your cases set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. Do you understand all of that?
Yes, ma'am.
And you want to reject those offers and have your cases set for trial.
Correct.
Okay. And I'm assuming, Mr. Eckhart, you've received all the discovery.
You have, Judge. We've got the media, we've got the discovery, and we've gone over Mr. Coleman's offer thoroughly.
Okay. And y'all, with regard to that evading any video, you've gone over that with, had an opportunity to go over that with Mr. Trahan?
Yes, ma'am.
Okay. Then, Mr. Trahan, I want to make sure you understand, Mr. Coleman, is there any reason to believe that there's any other reason or additional evidence that would change your mind on that offer?
Not at all, Judge. In fact, the offer, Mr. Eckhart has done a good job at getting it to where it is, Judge, and I have no reason to believe it'll change.
So, Mr. Trahan, I want to make sure you understand you have every right, obviously, to have a jury determine everything in your cases. That after today, I will not accept this plea agreement after today. Do you understand?
Yeah. Do you have all the evidence from the people who testified and
So I don't.
statement, victim statements and stuff?
So you have. I don't have anything. That's not my part of the job. So what Mr. Coleman has, he's required to turn over to Mr. Eckhart. I'm sure he has turned over every single thing he has. Mr. Eckhart has all of that, gone over what they have with you. And then any other evidence is just evidence at trial that could potentially come out. But I'm sure any discovery, written discovery and media, videos and things like that, pictures have been turned over. And Mr. Eckhart's going over that with you, correct?
Well, yes, but also I didn't barely have enough time on Sunday just to talk to my family about anything that had to do with signing for anything. So I definitely declined it because I don't have time to talk to nobody about nothing before I could even see if I could, because they were talking about hiring a lawyer to begin with. So that's what she had just told me on the phones. It was just, I really haven't had time to do anything. It was just like a forced play, like a quick thing. And I was just,
Well,
Judge,
like-
I told him that the court will let him hire a lawyer if he so chooses, but they're not going to change his date for his trial. Based on that, he's going to have to do so before the.
sure. Well, a couple of things. One, obviously, if you want to hire your own attorney or your family does, that's fine. But I do want to make sure you understand that the offer today is the offer, no matter who your attorney is. So they're not going to come in and get a different offer from Mr. Coleman.
Yeah.
So that is what it is. If you would like, I will reset your case 1 week to visit with whoever you want to and make your final determination before you go to trial. This is obviously very serious. I'm not trying to talk you into or out of anything, but if you're found guilty, a minimum of 25 years compared to 7 years is obviously a very big difference. You've had an opportunity to review the discovery that Mr. Eckhart has. That's not going to change. Whatever the video is, whatever the evidence is, it is for whoever gets your case. Your family hasn't seen all that, but you have. You have 1 week, Mr. Coleman, if you will indulge can leave that on the table for 1 week. I'll
Yes, sir.
reset your case 1 week. We will get an announcement one way or the other next week.
so I could get the discovery and be able to look at it myself. I have to.
So here's the thing, there's specific laws that don't allow defense attorneys to just hand everything to their clients. So he can go over it all with you. You can look at it, but for you to have it in your possession is not allowed. So Mr. Eckhart, if you would go back one time this week, go over everything again with Mr. Trahan, make sure he sees and reads everything, then we will get an announcement next week and that'll be it.
Okay.
Okay?
So,